In 2006, the state of Georgia enacted a law barring registered sex offenders from working for a church or school as either a paid employee or an uncompensated volunteer. The law was based on the legislature's conclusion that sexual offenders who prey on children present an extreme threat to the public safety and are likely to repeat their offenses if given the opportunity. Sex offenders who violated the law's ban on working in churches and schools were guilty of a felony, carrying a sentence of 10 to 30 years in prison. On March 30th, 2009, a federal judge ruled that this law was unconstitutional and issued an injunction barring its enforcement. It noted that the Due Process Clause of the 14th Amendment to the United States Constitution forbids states from depriving any person of life, liberty, or property without due process of law, and that a basic tenet of due process is that all persons are entitled to be informed as to what the state commands or forbids. And this means that a criminal law will be unconstitutional if the conduct that it prohibits is vague or ambiguous. And this was the problem with the Georgia law. In particular, the court focused on the term volunteer. What exactly did the law mean by prohibiting registered sex offenders from serving as church volunteers? For example, did it bar offenders from singing in the church choir, helping in a church kitchen, playing hymns, speaking during a church service, assisting with communion, praying for the sick, serving as an usher, or serving on a church committee? Many offenders seeking to avoid the harsh penalty for violation were deterred from participating in any volunteer activities in their church. The court concluded that the law's ambiguity rendered it unconstitutional. It noted that even without this law, churches had other tools to protect children, and it specifically mentioned background checks, chaperones, and prohibitions against contact with minors. Nationwide, there are more than 600,000 registered sex offenders, and the number is growing daily. Inevitably, many of them attend church. Churches that allow such persons to work as either employees or volunteers, especially with minors, or even attend the church, are exposing themselves to a significant risk. This risk can be managed, although not eliminated, by exercising a high degree of caution in monitoring and restricting such persons' activities. While according to this court, the risk cannot be managed by a state law barring offenders from working as church volunteers, it did mention other options that churches can use to reduce this risk, including background checks, the use of chaperones, and prohibitions against contact with minors. Church leaders should check with other local charities, their insurance company, and a local attorney to assist with the formulation of a policy that imposes sufficient protections to reduce the risk to an acceptable level. In addition, be sure to check with the offender's parole officer. Often, offenders are released from prison or given a suspended sentence, subject to the terms and conditions of a parole agreement. Such an agreement may limit or even prohibit attending or working in a church. It is important for church leaders to be familiar with these limitations.